Good morning, everyone. Thank you for joining us this beautiful Friday morning, at least beautiful and sunny here in Pretoria. Just want to say thanks for giving us your time. I think today is a very interesting webinar regarding the proposed labor law amendments, which in all likelihood will come into effect in 2026. But before we jump into that, I would just like to introduce myself. My name is Albert Mouton, and I am one of the officials with SMIEO, the employers organization. And I'd just also like to welcome my co-presenter of today's webinar, Mr. Ruben Nell, also one of the officials at SMIEO Employers Org. Hi, Ruben. How's it going?
Hi, all. How are you? Good. Thanks, Albert. Thanks for the introduction.
Awesome. No worries. All right. So I'm just going to kick things off, and then we'll have a bit of a discussion around just a few of the changes, the proposals as per the respective bills. It does, as you may know, last year, the Schedule 8 of the Labour Relations Act was already amended, somewhat favorably for employers. It's the intention of legislature and of the courts is to make life a little bit easier for employers, to not overburden companies with an internal court case where now it becomes a criminal matter. And I mean, some years ago already, there were decisions on this, the Avril Elizabeth Holmes case. And I think at this stage, the legislature is just trying to streamline the legislation to match what the courts are expecting. So similar to last year's amended Schedule 8, there are some favorable upcoming changes to the Labour Relations Act, as well as the Basic Conditions of Employment Act. But you've got to take your good with your bad. There are also some changes which are not per se favorable and will require some strategic thinking by employers, HR staff, etc. We will delve into it in more detail, but one example would be the double severance pay, which they want to implement, the 2 weeks versus 1. But without further ado, let's then just jump in a little bit further, and then we will discuss some of these topics. All right, so as I said, welcome. We're going to be discussing today the Labour Relations Amendment Bill, as well as the Labour Law Amendment Bill. So the first one applies more specifically to the Labour Relations Act and changes therein. They're not in effect as yet, obviously not. It's just a bill. And the second one pertains to more general legislation, but we'll just be focusing on the one of Basic Conditions of Employment Act. All right. And some of these changes or proposed amendments include, but are not limited to, things such as parental leave. You may remember there was a huge court case, court case decision last year that has changed the whole way we deal with parental leave and maternity leave. So we'll delve into that and how the legislation is trying to meet that court judgment and expectations in terms thereof. We'll discuss severance pay, probation, dispute resolution in general, insofar as changes may be concerned, regulation of flexible work arrangements, and the classification of employees and independent contractors. Simply put, what happens with your Uber driver and these modern forms of work where you aren't per se a true independent contractor. You may be economically dependent on one source of income, but to date, you haven't been deemed an employee in law. All right. I suppose at this point, Ruben, if you can just introduce this first topic and just delve into it a little bit, and I'll man the slides for you. Thank you so much.
Yeah. Thanks, Albert. This is a great topic. Just a little bit of a side introduction thing. Before the Constitutional Courts actually came out with the ruling, it was a couple of years ago, I was actually saying to a colleague of mine that I actually agreed with the way that they were actually going about this. Not going into, the gay rights and whatever, if it's male, female, whatever the case may be. But what happened in South Africa was that everything was changing around that, and same-sex marriages and adoption and all that kind of stuff. But the only thing that wasn't changing was the labor law and the labor relations surrounding this. And it was quite interesting to see the Constitutional Court rule with that, and then the LRA coming in to say, all right, well, everything else is changing, so now let's get on par with it. So basically what's happened here with the parental leave is that in the past, the normal leave would work with the 4 months. So your mother, let's say the female, either with birth or whatever the case may be, would get 4 months. So she would normally have to take a month prior to the birth of a child, a month leave, and then 3 months after the birth, or what a lot of people forget, or if a house mother, whatever that you call that doctor, the house doctor thing, to say that, okay, you can actually take a little bit earlier leave. So then it was 2 months. But now what's happened here is that they said, right, now the 4 months can be shared between the two partners, and it's for the two partners to actually regulate it through themselves. So, for an example, a dad will take 1 month, and then the mom will take 3 months, or 2 months, 2 months. And it's exactly what you and I were talking about earlier, Albert. It's interesting because they've come through with forms. So I'll make a very quick example of it. Let's say I work for Macro and my wife works for Pick and Pay. And now I say to Macro, like, okay, here's my adopted child, or here's my, the birth of my new child. My wife and I are going to take 2 months each parental leave. And then there's going to be forms that you need to fill out where Macro speaks to Pick and Pay and says, okay, well, here's my employee. He is now married to your employee. Here's 2 months. Here's 2 months. And they're going to regulate it like that, which is actually very interesting. But also now it comes into the thing where if there's a dispute about it, and it's exactly what we were talking about. If there's a dispute and, there's an argument and the employers are fighting with the employees or whatever the case may be, or the man and the wife are fighting with each other or anything like that, then it will always go back to the normal, just the wife gets 4 months and the husband gets 10 days. So it's quite interesting. And I think we actually need to keep a really close eye on how it's going to be regulated, because the forms I have not seen yet. I'm not sure if you've seen them yet, Albert, but I haven't seen them yet. But they have touched on the fact that, yes, it is going to be very closely regulated. So I think it's a very interesting thing, and I'm 100% in agreement with it. So like on your slides here, now they say one of the most significant proposed amendments relates to the parental leave and the restructuring of leave rights between parents. These amendments are rights largely from constitutional court developments related to equality and unfair discrimination between different categories of parents. That's what I've just spoken about. But then we go now with the adoptive. Now here, I think it's your third point of your slide. Originally, the adoptive child was only from about 2 years. Now they've increased that to 6 years as well, which is also very interesting, because it means that because the Constitutional Court made that ruling, the labor relations are actually leaning more towards saying, yes, we are in agreement with the Concourt, and they are trying to develop themselves surrounding that Constitutional Court ruling. However, people, I have a very strong feeling that people are going to try and abuse it, to say that, okay, no, I'm going to adopt now 5 children. So now I'm going to have 4 months leave, 4 months leave, 4 months leave. So it's not about that. It's only one child. And you can just step in here, Albert, if I'm correct in saying that. You can't abuse it to say that, oh, no, I'm going to adopt now 5 children every couple of months so that I can get, paid leave from the department. I don't know if you want to add anything there on that specific point, Albert.
Thanks, Ruben. Just to say, yeah, in a general sense, the parental leave, let's use the example of a polygamous marriage where, the mother obviously can't, to my mind anyway, and I think medically can't have more than one child per annum. But the father in a polygamous marriage can certainly have more than one wife and more than one child in that respective year. So they do make provision that individual, in that example, the father would only be able to claim once per annum to have parental leave or share in parental leave. And thank you for your explanation earlier. Just to emphasize, if parents share in the 4 months, it's the 4 months and the 10 days. I know it's somewhat strange, this extra little 10 days hanging on, but it's actually sharing in the full pot of the 4 months and 10 days. If, however, as you mentioned, there's a dispute, mom, in the conventional example, mom will get the 4 months and dad will still get the ordinary 10 days parental leave. But yes, you're spot on. And yeah, I think that, as always, it's good intentions, and we'll just have to see from these proposed amendments what further case law will develop in due course. On the issue of UIF, although we're not covering the unemployment insurance fund today, those changes are also being made. We'll have to wait and see when it becomes law that dad, in the traditional example, is also eligible for UIF claims. But to date, as per the Fundweg decision, and we did a whole webinar on this last year, if people want to go and look online at that webinar, but to date hereof, dad is not eligible to UIF if he shares in that pot of 4 months. And, well, he's only eligible for 10 days, but if he shares in the other 4 months with mom, he's not eligible to any UIF. So at the moment, it's a bit of a discouraging situation for a family, because you'll get, mom will have less time off for the baba, and also the family unit will get less money in until those amendments have kicked in. All right. I think if you're fine with that, I can then move on to the next slide.
Yes, yeah, I'm fine with that. Thanks for the clarity there, Albert.
Brilliant. Thank you, Ruben. Let me just get going. There we go. Ruben, if you can just tell us what's happening with the severance pay, and is it good? Is it bad? What's your your prognosis on this?
So how much time do I have here? Can I speak for 3 hours? So basically what they're trying to do in the severance pay is increase it from 1 week to 2 weeks. So I'm just going to dive in a little bit about that. So when a company goes into retrenchments and they need to restructure or retrench employees based on their operational requirements, every employee is entitled to a package, like we like to call it, the outstanding leave, the severance pay, the notice pay, all of that kind of stuff. So basically what it means is that everyone will know severance pay is now at the moment, as per the BCEA, it's 1 week's pay for every completed year's service. A lot of our members get confused. Let's say someone started in June 2015 and they worked from June 2015 to, let's say, March 2016. They haven't completed a full year's service. So if you haven't completed a full year's service, you're not entitled to severance pay. However, if you've completed a full year's service, then you're entitled to 1 week for every full year service that you completed. What they're wanting to do now is increase that from 1 week for every completed year to 2 weeks. It's very interesting though, because MIBCO, it's the Motor Industry Bargaining Council for those who are joining us today and don't know what MIBCO is. MIBCO has had the 2 weeks for every completed year for a number of years now. There's an upside and there's a downside. The upside is that employees will get a larger, well, I don't want to say larger, but they will get an increased severance pay. Let's take it on an employee that earns minimum wage. He's going to get 2 weeks for every completed year's service, which is fine. But now you're looking at, let's say you're looking at an employee that earns 100,000 Rand a month that's been working for the company for, let's say, 15 years. That's going to be a substantial amount of severance pay, not regarding the leave or the notice or anything else like that, just talking about the severance pay. So again, employers are going to have to look at, they're really going to have to dive deep into the fact that, wow, this is going to cost us now a bit more. So let's see if we can rather focus on looking at alternatives. When you go into a retrenchment process, you have to look at your alternatives to retrenchment, because remember now the whole point, especially in this country, is to save jobs. No one wants to see people lose their jobs. So an employer is going to have to literally dive so deep and say, look, well, this is going to cost me X amount of money. Is it actually worthwhile going through this whole entire retrenchment process, knowing that these employees are going to get now 2 weeks for every completed year service? Or can we look at alternatives and see where we can maybe save cost and say, all right, instead of retrenching an employee as a whole, maybe cutting a salary for a limited period of time, because it always goes down back to that factor that a half a pizza is better than an empty box. So I think we're also going to have to keep a very close eye on our, our members and their employees, and to say that, look, have you divulged this? Have you dived deep into this and actually done the numbers and crunched the numbers and said, is it actually worth going through or not? But like I said, MIBCO has been doing it for a number of years now. They've got their collective agreements, and that's 2 weeks for every completed year. So when this comes in, I think, it's gonna take a big effect on employees, especially when they're looking at retrenching upper management level, senior employees, and not your your normal minimum wage workers, anything like that. So I'm not sure if you want to weigh in here as well, Albert.
I just wanted to say, yeah, I agree with you. I think to some extent, it's just a helping hand trying to help those in economic dire straits. They've lost their job now. It's a little bit extra for them to help pave the way in that gap between finding new employment. But to some extent, I can't help but wonder if it's not an intention to create a bit of a deterrence. Companies will be, especially with a large workforce, a little more apprehensive just simply going the retrenchment route. As you said, it's better having half a pizza than an empty pizza box. And I think at the end of the day, if we want to get legal about it, it's easier to get away with the retrenchment than some of the other dismissals. So I think it's maybe putting the brakes on a little bit, that it's not so affordable, if I can put it that way, making it a little tougher for employers. But even where it is genuinely real operational requirements necessitating retrenchment, employers now will have to consider starting the process earlier. Really, to your point, looking, are there not alternatives? Can we not agree to change terms and conditions by lessening the salary and keeping the workforce going? So, I think it's a very blanket cover statement. One would have to look at the specific circumstances of that respective case, but it certainly does raise eyebrows for a lot of employers at this point. All right.
I agree.
All right, just moving on to the next slide. All right, so this is quite an interesting one, and if you don't mind, Ruben, I'll just jump in here, and
Yeah,
then you
go for
can
it.
jump in and add if necessary, or if you've got any questions on this. But the to date, I mentioned earlier the example of Uber drivers. There's a bit of a gray area, no man's land in our country where to some extent, yes, you get real independent contractors. You get a plumber, for example. He's got his vehicle. He has multiple clients. He's not economically dependent on one source of income, one client. That, to my mind, is a good example of a true independent contractor. Then you have someone like an Uber driver or Checker 6060, that sort of thing, where quite frankly, they depend on the platform or one source of income. And to date, there are some protections in law. Just because you put the title on a contract of saying independent contractor doesn't mean you can always get away with it if the substance is that of an employment relationship. Section 200A has 7 criterion where if even one exists, the presumption is that employee or that individual is an employee, but that's a presumption only applicable to those under the earnings threshold, which is amended from time to time. But I think the proposed amendments in relation to flexible work, on-call employment, etc., independent contractors, is there to further bolster legal protection, to give some, but not necessarily all rights. So simply put, the proposed Basic Conditions of Employment Act amendments also seek to regulate flexible work arrangements and on-call employment structures more closely. There's also an example where you only work for one company. They don't call you an employee and you don't have formal hours. You just get shunted around. They phone you if and when they need you. And there's no guaranteed hours. And they also cancel you and you're left in the lurch a lot of the time if they just cancel your shift that morning and you're already in the taxi en route to work. So they're trying to bring in more protections. Historically, South African legislation has not directly regulated 0-hour or on-call work arrangements in detail. However, the proposed amendments now introduce provisions aimed at regulating employees who work only when required by employers. The intention appears to be to extend protection to those workers in these vulnerable, unpredictable arrangements. All right, so for example, you can see potential future regulation may include a minimum amount of hours for a specific worker, allowing them to have predictable hours and expectations, to know when to be available. The concern here is someone might have more than one employer or one source of income, and now they put the other source of income on hold because you want them to work tomorrow on a shift, and then that morning suddenly that shift is cancelled. There needs to be some protection for those individuals. So they want to get more contractual in terms of terms and conditions. These changes may have significant implications for industries that rely heavily on labor flexibility and shift-based operations. And I just want to read something here quickly, just to make the point even more clear. Some of the key aspects proposed specifically under Section 9B would be written contract requirements. Employers must set out in writing the guaranteed hours, maximum hours, periods of availability for on-call workers, notice periods. The amendments mandate reasonable notice periods for requiring an employee to work or for cancelling a scheduled shift. Compensation for cancellations. If work is cancelled without sufficient notice, employers will be required to compensate the employees for those lost hours. How are we going to regulate this? We'll have to wait and see. I don't quite understand the practical side of it to now determine if it was reasonable or unreasonable notice of cancellation. But the scope, these protections apply to employees, but the proposed amendments also include a broader definition of an employee. As mentioned, gig economy workers, Uber drivers, etc. They've been left out and somewhat in the lurch for a long time, and they're trying to bring in certain protections in relation to them. All right. And sorry, Ruben, before I proceed, anything to add on those points?
I was just about to interrupt you there quickly, Albert. Again, it's exactly like you said. Now, we're not too sure on how we're going to regulate, especially when it comes to notice periods. So I really like the example that you made of a plumber and an Uber driver. A plumber with his own bucky. He's got, let's say, 20 clients. He's not reliable on one source of income, not one platform. And I like that word that you use, the platform, because if you take an Uber driver, he I was reading an article a couple of years ago where they said Uber is one of the best companies ever because the owner, who started the company, he's the biggest transport company in the world, but he has not got one vehicle in his fleet. Because it's the Uber driver's vehicle, but you're still using that platform. And yes, the Uber driver will have other things on the sideline, such as, a Bolt, or he can be a restaurant manager or whatever the case would be, and they do it in their spare time. However, they're still using that platform as Uber itself for their primary source of income. And when you dived into a little bit about the notice periods and how we're going to justify it and what's acceptable, what's not acceptable, I think, again, we're going to have to keep a close eye on it as well, because let's say, for an example, not an Uber driver, but let's say an independent contractor is now, he's working for someone, and that's his primary source of income, and he's been scheduled to go and do a call out for a customer, let's say on a Wednesday at 10 o'clock, and the business said this is going to take a minimum of 4 hours. So now he's booked out 4 hours of his time to go and service his clients, and then they cancel. Now he could have been doing something else in that time. So obviously, in terms of that, the owner would have to compensate the employee for those hours, like you said. But in an event where it's not like that, and you look at it from an opposite side to say, okay, it was his last minute cancellation, it's not the employer's fault that this happened, you can now go and do something else, then I think that would also be justified to say, well, I'm not going to compensate you for these hours because it was a matter of force majeure, that kind of stuff. So I just wanted to touch on that a bit.
I think it's very contextual. There's no blanket cover answer. It does depend on the exact circumstances. No, thanks for that. So, part of this overhaul and trying to protect more employees or workers, they now want to redefine or include certain individuals in terms of who is protected by certain employment law rights and legislation. So one of the most potentially far-reaching proposed reforms is the expansion of the concept of employee. The proposed amendments introduce broader definitions aimed at extending labor protections to workers, and that's a key word, workers, who may previously have fallen outside the traditional employment relationship. So specifically, they want to include in the Labor Relations Act Schedule 11, and the definition would read as: an employee means an individual other than an employee as defined in Section 213 of the Act, the Labor Relations Act. So they're not taking away or amending that definition. They're actually adding to that under Schedule 11. And then they go on to say, who works for a person that is not a client or customer of any profession, business, or undertaking carried on by the individual. So Schedule 11 would also provide for the definition of employer, meaning any person or entity for whom an employee works. So it's a little bit somewhat confusing or convoluted for me, because then they use the word employee, and then simply put, and I'm going to get to this in a moment, they don't necessarily have all the rights as would a normal employee as per Section 213. But we'll delve into that in a moment. So what it does give you, this Schedule 11 will give those employees or workers, it will extend the rights contained in Chapter 2 in terms of freedom of association, Chapter 3, collective bargaining, and Chapter, oh goodness, my Roman numerals, is that 6? No, that is...
That's 4, I think.
4, my apologies.
Because V is 5 and 1 VER is 4.
Yeah, no, perfect. And the right to strike. So essentially, they're getting some protection which they never had in the past. But as I mentioned, they're not going to get all the protections. So these are being given to persons who satisfy this expanded definition, who fall into that category. Existing trade unions will be entitled to alter their constitutions to enable them to recruit workers falling into this category. And that for me is key. So the purpose behind this is to allow these workers, not traditional employees, to have the right of freedom of association, collective bargaining, and the right to strike. And the moment the unions get involved, that inevitably means that they will pursue matters of mutual interest and try to increase the scope of their rights. So this is legislature's way of trying to not give them the whole spectrum of rights, but a foot in the door to actually then, through interest disputes and through collective bargaining, maybe even get full-on employment and have all the ordinary protections in terms of the Labor Relations Act. All right, sorry, I'm on a bit of a tangent. Anything from your side?
No. I think you've actually covered. I think you've covered a lot there, Albert. I did want to dive into who is redeemed an employee, but like you said, that word worker is very significant. And now I like where they say that, with the actual definition of it, it means that any individual, other than the normal terms of an employee, as per Section 213, I think it is, that works for another person who's not a client or customer of any, profession or business or whatever. So it's all goes about, are you rendering services for someone else? And if the answer is yes, that's where the whole scope comes in now. So yeah, it's quite interesting.
It's not to say it's eliminating a true independent contractor. It's just the situation where and I know and most people know this person is not a true independent contractor running their own business. They are dependent on one or two companies, and it's just to avoid them being messed around so that they can increase their livelihood and protect their families.
Exactly.
The last point at the bottom, there's also an amendment to the Basic Conditions of Employment Act under Section 50A, which similarly has this new version of a worker or employee. It says, notwithstanding the definition of employee, for purposes of Chapter 8 of the Basic Conditions of Employment Act, employee also means any individual who performs work or provides services for another person and who is not conducting an independent trade, profession, or business in which the person receiving the work or services is a client of the customer or a customer. And what's interesting is, and it's not on the slide, but I know that the intention in terms of these proposals is also to allow them to have the right and protection of inspectors coming in to ensure compliance with contracts, all these things we've mentioned, certain work hours, payment if there's unreasonable cancellation at the 11th hour. So imagine that on top of collective bargaining and rights to join unions, now then also an inspector can come in and actually give the employer a hard time in terms of dealing with these individuals who aren't traditionally employees. All right. So the purpose of the amendments appear specifically aimed at gig economy workers, meaning, you get a gig, not a formal job or profession, platform-based workers, your Uber drivers relying on an app, casual labor arrangements, and economically dependent contractors. I think the last one goes to the traditional example where you just slap the title of independent contractor on the contract, but we know in essence it's a true employment relationship. All right. The intention is to adapt labor law to changing forms of work and to prevent businesses from avoiding labor protections through contractual structuring alone. You can't get away from certain obligations simply by the wording of your contract. All right. Yeah, as mentioned or alluded to, it will significantly increase scrutiny of independent contractor arrangements across multiple industries. All right. So this is sort of overlapping with what we've discussed already.
Yeah.
The distinction is sometimes blurred. I'm not going to go into all of this. I think we've covered this. Maybe you can just quickly, just for the audience, just touch on the status quo. How have things been done to date with that Section 200A and who is deemed to be an employee, the presumption?
Yeah, so it all boils down to and to a lot of people on the webinar this morning, it's going to sound like I'm speaking French, but it boils down to something that we call the rebuttable presumption of the dominant impression test. So what it was 7 questions that are asked by any independent adjudicator, like let's say a commissioner at the CCMA. It said, did you work more than 40 hours over the last 3 months? And did the person provide you with tools to do, to render these services for them? And it's a whole bunch of questions that you asked. And if you answer yes to any of those questions, you are now presumed an employee of that company. But now with these amendments, it goes a lot into detail of the simple question, are you rendering services for this person? Are you a person? Are you rendering services for this person? And is this your primary source of income? Like, for an example, an Uber driver, that's his platform, not a plumber that has 20 of his own clients, because then you're not an employee, because you're working for yourself, for your own clients. But now if you're rendering services for another person, for that person or that person's clients or customers, it's now bringing a blanket over the entire thing to say that, yes, you are now going to be deemed as an employee because this is your primary source. And that is how you are going to, like you say, Albert, feed your family and, do what you need to do. So it's quite an interesting way to look at it. And I think there is going to be quite a few arguments with employers to say that although I am his primary source of income, he is still rendering services, yes, to my clients, but he is now invoicing me per month at his own fixed rate. But that's what the whole amendment tries to move away from. They want to move away from an IC or the independent contractor. They want to move away from that and having people invoicing, their clients and then them paying, because it's like you say, they want to enjoy the protection of the rights that fall under all the sections of the BCEA and everything like that. So it's quite interesting.
All right. No, thank you so much. So you would agree, in essence, this was already the status quo, the protections in existence, and now they just seem to be making it even tougher for employers to try and get out of employment.
Correct.
All righty. So as mentioned, it could allow you to have collective bargaining rights, organizational rights, strike action belonging to a union, and ultimately employers should therefore carefully review their contracts. Obviously, we at SMIEO can assist to see, are you safe? Are you not? Is it worth calling the person an independent contractor, or are you just going to put yourself in trouble down the road? All right, so it's good. Although this isn't law yet, it's good to take stock of what you have in your policies and contracts and prepare for what seems to be the inevitable changes. All right, Ruben, do you want to tackle this one?
Yeah, do I have another 3 hours again? So the changes to probation, again, it kind of seems that they're actually helping employers now. Now, back in the day, if I can say that, everyone thinks that the CCMA is there to protect employees. And it goes back to that saying the CCMA stands for come collect money again. It all goes back to that. And what I've found in my experience is that a probation, an employer will come and say, look, I'm going to hire this employee, but I want to put him on probation because I don't know if he's going to fit in to my business or if he's going to do the work properly or whatever the case is. And if he doesn't, then I can say, oh, after 3 months, okay, cheers, I don't like you anymore, goodbye. Before now these changes are coming in, how probation works is that you'd have to sign a contract with the employee with a probationary clause in there of 3 months. You can extend it. So I'm not going to dive too deep into that, but it would be on the rider that you need to sit with the employee at least on a 2-week, bi-weekly basis, whatever the case is, and say, all right, this is what we expect of you. This is what you're doing right. This is what you're doing wrong. We are going to provide you the necessary tools or whatever the case is in order for you to achieve what we need you to achieve. Now, with these new changes coming in, they're kind of steering away from that to say, all right, you don't have to, as an employer, do so much in the employee's probation period. So when the probation period ends, you can say, all right, well, this is what you've now been doing over the 3 months. We have looked at you. We've assessed everything that you've done. And unfortunately, you haven't passed your probation period, and then they can terminate the employment relationship on a mutual ground. And I will say, and you might argue here with me, Albert, I will say, I don't necessarily agree with that, because the entire purpose of the LRA, and exactly like I was saying earlier, in South Africa especially, is to maintain jobs. No one wants to be dismissed. No one wants to leave an employment relationship. And I tend to lean towards the older way of doing things, where you actually do sit with the employee every 2 weeks and you make a minute, you make minutes of the meeting where you've sat with this employee to say, look, this is what I need you to do. These are the targets that I need you to reach. You aren't doing that. What is the problem? What is the issue? How can we as a company help you to achieve these? On the one hand, yes, good. On the other hand, which I also now tend to agree with a little bit more with these changes, is that an employer can't baby you. We're not there to spoon feed someone into saying, okay, let's just do everything for you in order for you to do your job correctly. There's a reason why they were hired. So the new changes with the probationary clause is they allowing employers to, again, assess over a 3-month period, or if they'd extend it to 6 months with justifiable cause or whatever the case is, to say that, look, this isn't going to work, let's rather part ways. Again, with in the past, if someone had to refer a case to the CCMA for an unfair dismissal related to probation, the onus, so what's another word for onus? The proof would be on the employer's side to prove that yes, they did follow the steps and they did consult with this employee, etc., etc. However, now the onus is not necessarily on the employer so much anymore to say that, all right, he didn't pass his probation because of X, Y, Z. They can. It's a very gray area now for me personally, because if an employer says, well, they didn't pass the probation, why? Oh, because he didn't do this right and he didn't do that right. Who's to say, is that fair or not? So it's going to be very interesting to see when cases come through now, when these changes come into effect on probation, to see which way the rulings go. And I would actually like to see a case go to the labor court, or even labor appeal court, because I think once that ruling has come out, that's what we can base now, our advice to our members going forward, to say, all right, you don't necessarily have to do so much. You don't have to dive so much into it. You actually can just scrape it on the outskirts, and you can actually, I don't want to say get away with it, but you can do it that way. I'm not sure if you agree there with me or not, Albert.
What I'm hearing and understanding is you saying that you would advise to proceed with the status quo in terms of following due process and inquiries and evaluation. But that said, and with respect, I'm on the other side of things. My understanding and view of these proposed changes is actually very favorable to employers and makes life a little easier. It's not so burdensome. So what's happening is the proposal says that there's two things in terms of dismissals and procedure. Number one, the proposed amendments seek to simplify dismissal procedures during probationary periods. So that's the one issue. And on the other side of the coin, it also says the proposed new section 1883 of the LRA provides that procedural fairness in misconduct or incapacity dismissals will simply require that employees receive an adequate and reasonable opportunity to respond to the reasons for dismissal. So I just want to split those two for a moment. Let's start with the last one. Simply put, if you catch someone stealing or doing something in terms of misconduct, or let's say they suddenly ill health, they're incapacity, they're incapable to do their job, this amendment or incoming section confirms all the case law I was referencing at the start of the website to say that going forward, the legislation, like the courts, will accept that you don't have to have a whole big internal court case as if you're in court. We still, I tend to agree with you. I think rather too much than too little. Obviously, as SMIEO or SMIEO, we would still rather come in and do the formal process and audi ultram partem, let them state their case, etc. Rather too much than too little. But the Act is being very generous, or the amendments will be very generous to employers to say all that is required is the employee receives an adequate and reasonable opportunity to respond. And it's already tried, that there's even case law on this. One could, in the right circumstances, even do this on the papers. But that's normally your more corporate matters. I think when it's your industrial sort of business, it's better to have an in-person inquiry. So that's the second, or the one issue. The top point is an exception to the section 1883. The top point pertaining to probation and the changes that are coming up. Let me just go to the next slide. The amendments propose that employees may not enjoy full unfair dismissal protection during the first 3 months of employment. So this is a real Donald Trump style thing of you're fired, where the legislation will change to say that it is not expected of the employer to have all this evaluation, have a hearing, have an incapacity or probationary dismissal, whatever it might be. So the amendment will say for 3 months, you're safe. There's no Labor Relations Act protection saying that there must be a fair dismissal. And arguably then, obviously, to my mind, CCMA would lack jurisdiction to decide anything if the employee does run to the CCMA within that 3-month period. If you just say, listen, I don't think this is working, we're not compatible. Again, to your point, I think it's better to document things, and in the interests of fairness or ethics, try and give them that chance. In case they try and argue, it was 8 months and it wasn't during probation. Have your ducks in a row that you can show, no. In fact, it was within the probation period. Therefore, CCMA lacks jurisdiction. There's no protection. So cover yourself, but in essence, you don't have to stress as much. It's going to make business easier for employers because let's face it, you get your career CCMA employees who simply say the right things, do the right dance, and the moment you hire them, they don't want to work, and they want you to pull the trigger and fire them so they can try and get a settlement at CCMA. And the intention here is to align South African law with international law somewhat more, so that it's easier to assess if someone is compatible with the business. All right, it's not only 3 months. In contract, in writing, you can agree to a longer period if it's objectively fair under the circumstances. It can't just be an arbitrary number. You say 5 years, because they're going to shoot that down and say, well, that's just you trying to circumvent the person's rights and circumvent the law. So it has to be reasonable in relation to the job and the nature of the work. All right, so this does represent a significant shift away from the highly formalized disciplinary processes, or actually incapacity processes if it comes to probation. Normally it's a no-fault issue. But yeah, likewise, similarly, even for misconduct, I suppose in that 3-month period, if you catch them stealing, again, they don't have labor law rights. So you don't have to now go through a laborious disciplinary inquiry where witnesses have to attend the inquiry as well as the CCMA. So I think that will streamline business a little bit. The practical effect of this: the proposed amendments may provide employers with greater flexibility when assessing the suitability of new employees. And for many employers, the current disciplinary process during probation remains overly formal, time-consuming, and it's quite burdensome in terms of admin. So the proposed reforms appear aimed at reducing this complexity and focusing more on practical fairness rather than all these procedural technicalities. All right. Sorry, Ruben, I was going for quite a while there. I don't know if you've got anything to add before we move on.
No, it's all right. I just wanted to add one thing that I just personally think on that. I like how you said that rather too much than too little. So yes, I do agree with them saying that it's making it a little bit easier for employers to avoid the long and time-consuming disciplinary hearing, your charge sheet, your hearing, your witnesses, all that kind of stuff. However, having said that, I think it focuses more on like the smaller businesses, and that's where all these changes come from. It's because they're focusing on the smaller businesses that don't have employers organizations like SMIEO or SMBO or whatever the case is. However, I still would lean more towards rather be safe than sorry, rather do too much than too little. So like you said also in the beginning, it's very interesting because it does give employers that leeway to not necessarily go through the entire hearing and all this administrative issues, and it's time consuming, yes. However, I always like to say rather be safe than sorry. So rather too much than too little. So yeah, that's just my personal view on things. But it's interesting. We'll have to keep a close eye on it to see if let's say an employer that's not one of our members at SMIEO does do it, and then it goes to court and the judgment is made. It's going to be very interesting to read through that judgment to see what's actually the, for lack of a better word, bare minimum that an employer has to do in order to cover themselves when it comes to employees on a probationary period. So yeah, that's all I wanted to add from my side on that, Albert.
All right, moving on to limits on claims by high earners. This doesn't apply to most employees. However, and it's yet to be seen if this will be deemed unconstitutional if someone takes this to the Con Court. But what they want to do is essentially put a cap on what you can get out of CCMA. That if you are earning, and this is the first proposed threshold, if you're earning above 1.8 million, correct me if I'm wrong, I think it's about 150,000 Rand a month, then you are capped to only claiming up to that amount. So if you earn 5 million a year, you can't get more than 1.8 million from the CCMA. All right. Further, or in addition to that, you cannot, unless it's an automatically unfair dismissal, for example, you're dismissed based on arbitrary grounds like race, pregnancy, anything like that, under Section 187 of the Labor Relations Act, unless it's something just discriminatory. In those circumstances, you can get your job back. But if it's an ordinary dismissal for misconduct, whatever it might be, corporate crime, whatever, you cannot try or seek to get your job back. You are capped at only going for that 1.8 million. So that's quite interesting. And the reason I said we'll wait and see if this gets challenged in Con Court is, to me, it seems somewhat unfair, personally. I think that a person shouldn't have their rights taken away, shouldn't be constrained in what they can claim if they were unfairly treated. All right. Let me just move on to the next slide quickly. All right, so that amount, that 1.8, will change from time to time depending on the relevant time. But the purpose behind this is to reduce excessive litigation. I think, and this is supposition, but I think the rationale is often the high or big cases with those sorts of numbers, it's the big corporates, your discoveries, etc. Just one example. And I think the concern is when there's this laborious, dragged out, protracted case. The entity itself is in limbo. It doesn't quite know if it can employ or appoint a new CEO or a exec, whatever position it might be. I think the intention is to try and assist big companies, big corporate, to get the ball moving with the new employee so that they're not held to ransom or in limbo until the outcome of a CCMA case, which often inevitably is going to the labor court on review and takes years to finalize. So it's reducing excessive litigation, limits the high value dismissal exposure. It's also protecting them from exorbitant amounts of money, which could cripple some businesses, and ultimately align South Africa with more of an international approach. All right. Sorry, Ruben, do you have anything to add on that point?
No. You covered everything. I actually also wanted to just touch on the automatic unfair dismissal of the arbitrary ground, but you did cover that, so I'm happy with that.
Oh, apologies. All right, no worries. So carrying on from what we just discussed now, the intention is also to limit, and again, I don't know if this is fair in law or constitutional, but the intention with these high earners is to limit their recourse. Traditionally, you can go to both labor court and CCMA for solatium, for the unfairness side of things. It's, I think, the only, if not one of few forums, and I believe it's the only, that deals with fairness, not law per se, but what is fair and what is objectively fair. But in reality, it's a very subjective thing, depending who you're asking. But there you go for compensation solatium for the unfairness, where the procedural or substantive of a dismissal. And to date, in tandem with that, you can go to labor court for a contractual claim, damages claim. It's the fact that you claim the dismissal was unlawful, not only unfair. And you can go for both cases. You can have one in the CCMA, one in labor court, and win both cases. There's no issue with that. However, the amendments seek to reduce your rights or take away your options, in that you must elect which one you want to pursue. Are you going to go for compensation in CCMA, which is capped to 12 months, or will you try and seek recourse in the labor courts for damages or contractual compliance, whatever it may be? But from the looks of it, if you pull the trigger on the one, it kills your potential to go on the other case. All right. So yeah, anything from your side on that, Ruben?
No, you've covered it brilliantly there.
All right, thanks so much. I wish that I was in that category, but in good time.
I was just going to say, yeah, I mean, look at the UCAP with the 1.8 million. Imagine now if someone actually went and pursued two matters, the one in the CCMA and the one in the labor courts, 1.8 times 2. I mean, sure.
I don't think too many people are in that category, and I don't think the union is kicking up too much of a fuss. You know, all respect to the unions, their membership or clientele is normally, you know, your laborers, etc. So I don't think they're too bothered about this. And I think the only way we'll see any challenge will be with some exec taking this to the con court, unhappy with these changes.
Private attorneys, that kind of stuff. Right. Yeah, I agree.
Right. All right. Just the final one, section 188A, and I'm not sure if our members have dealt with this before. And this is just a bit of a tip, but just a bit interesting from my side. Essentially, you know, there is a mechanism under section 188A of the Labour Relations Act where you can have a commissioner come to your premises, for example, or a neutral environment, and act as the decision maker and to determine whether or not the person is guilty of misconduct, for example, and is dismissal appropriate. And in those circumstances, if the commissioner agrees, yes, it's appropriate, that's the end of the case. They can't go to CCMA. To date, that has been an option for parties to engage on at the time of the issue arising, or if you were over the earnings threshold, you could contract this at inception of the relationship. You could say, if there's ever a dispute, we'll rely on this mechanism, and let CCMA come to our premises and come conduct this process. However, the changes will now allow even employees, lower earning employees under the threshold, to also at inception, or at any time for that matter, agree in writing. So that protection that used to cover them seems to be revoked now, or will be revoked. And I think that's just trying to make life easier for parties to contract how they want to deal with their dispute resolution. All right. So as mentioned, importantly, parties can now upfront in employment contracts agree to this sort of arrangement. And it just streamlines some of the procedures. All right. I don't know if you want to assist me just to wrap up. I think we'll go to Q&A very soon. But in a general sense, I think we can both agree there's a lot of implications here for employers. I think a lot of it is being preemptive rather than waiting for the changes to slap you in the face. Get ahead of things, get certain drafts in place, do a bit of research, contact SMIEO. You want to be ready for this the moment these proposals or bills come into effect.
Yeah, no, I agree there, Albert. I think it always goes back to what I say. It's all about preparation. 99.9% of the time, it's preparation. So rather be overly prepared so that when they do actually come into, like you say, when they do come into effect, you already know that you've got your policies, your procedures in place already from us here at SMIEO. That covers you already. So that takes the stress off employers. So it's a very interesting thing. And that's why, you know, so many employees are now are joining employees organizations, because not everyone is going to know this. So yeah, preparation is key for me. I think you've covered that brilliantly again as well.
Thanks so much. I think at this point, we'll then open the floor to any questions if people want to type and send them to us. Otherwise, you are welcome to put your mic on and have a chat with us. We'll try and answer your questions. Obviously, as we mentioned, we will still see how things unfold, practically speaking. But yeah, maybe we can assist today with the theory side of it. Let me just stop sharing my screen. I can't see if there's any hands. All righty. Oh,
I see
Daveen
Davina saying
says,
the mic option's been disabled.
so does that mean participants can't speak to us, but they can still type to us? I'm just going to open up the chat. Anyone is then welcome to type out their question, otherwise to contact us afterwards. I see Daveen is typing again. She says that's correct. So unfortunately, our participants can't actually speak on the mic, but they're welcome to type a question. Otherwise, if there are no questions, we thank everyone for joining us today. I certainly find it to be a very interesting time in our labor law, how it's developing and changing. Got to take the good with the bad, but yeah, now's your chance if you do have a question.
Mic's enabled. All right, so the microphones have been enabled, yeah, Albert.
All right, so try your mic if you have a question. Otherwise, I think I'll just give it a minute just for everyone to get their ducks in a row if they want to get the mic on or type a question. And if there are no questions, we'll then wish everyone a wonderful day and log off. I hope we made sense. I hope there are no questions.
I was just about to say the same thing, Albert. I hope we made sense. I hope everyone understands everything we chatted about today.
Hi, Albert and Ruben. My name is Anne.
Hi,
thank
Anne.
you very much. It was a great informative session and learned quite a lot. Thank you.
Thank you, Anne. Truly appreciate that. It's good to know that it's not just AI participants, not just recording devices, that someone was listening. Thank you for that, Anne.
Thank you, guys.
All right. I think on that note, thank you everyone for joining today. Thank you to you, Ruben, for joining and participating in this. As mentioned, it's very interesting and very informative. And if anyone is scum and wants to send us a private message, they're welcome to contact us, and we can just have a one-on-one call or even consultation. All right. Thanks, everyone. Have a wonderful day.
Right. Thanks, Albert. Thanks, everyone.
Cheers.